We're in public, so the media knows the cameras have to leave. But it is televised, so you'll have access to it.
They only had green tea last. I hope you like green tea.
I do.
Good.
Okay, is everyone here? Where's Mr. Christofferson? Okay. Okay. Yes? Yeah, Mr. Reid.
Why don't we just wait till the actual appointed meeting time, beginning time? I just thought it was a good idea to gavel the session to get the media out of here. But let's give the minister the time and Mr. Christofferson the time they need to.
I'm going to read the just the mechanics so it's out of the way because he won't care about that. So good afternoon. We're now in the 27th meeting of the Standing Committee on Procedure and House Affairs for the first section of the 42nd Parliament. This part of the meeting is televised. We're resuming study of the question of privilege related to the premature disclosure of contents of Bill C-14. I would like to just report on Mr. Reid had asked a question of the researcher on similar type of cases in New Zealand and Australia, New Zealand, the UK, and Australia. And the quick answers, unless you want to hear from the researcher, is that Australia hasn't answered yet, and New Zealand and the UK do not have similar provisions. It's totally different, and he's going to send you a briefing note with the details of that.
Thank you.
That's okay?
That's very helpful.
And I want to be exemplary in starting on time, which is not yet. 2 minutes. No.
So the camera's going to be on you for the next 2 minutes.
Well, they shouldn't. They don't. I'll just say who it is now so it doesn't take up committee time. But two of our colleagues that retired in 2011, who are sort of somewhat icons of Parliament, Derek Lee will be here, who wrote this book, Power of Parliamentary Houses to Send for Persons, Records and Papers. So that's kind of interesting. I think he's the only member in history. He was almost the Dean of the House. There he is. Mr. Lee is coming in. He was the Dean, except for Mr. Plamondon, he would have been the Dean of the House when he left. And he's written this book. Derek, I want you to sign my book. And he's also, I think, the only member of Parliament in history that sat on a committee for 20 years straight, the scrutiny of regulations. So he's got lots of background there. And Paul Szabo, if you remember, spoke more times in Parliament than any other member for the years he was here. So very interesting former members here in the audience today. And so we're at the, where's Jose? You take that to Derek. So I'd like to, is David's here now? Yes. I would like to welcome our witness, the Honourable Jody Wilson-Raybould, Minister of Justice, and the Attorney General of Canada. Thank you very much for coming. I know all ministers are very busy, so we really appreciate this. Without further ado, I invite the Minister to make her opening statement of 10 minutes, and then we'll proceed to questioning.
Sure, thank you, and thank you to all the honourable members here, and thank you for the opportunity to appear before committee to address the alleged breach of privilege with respect to Bill C-14, a matter that I take incredibly seriously. First, I'd like to speak to various measures and policies that are followed in my department and by my department and my exempt staff to protect legislation prior to its introduction. I want to be very clear that none of my staff nor any of my officials were involved in any alleged leaks in this matter. Second, I want to highlight that the drafting of legislation spanned several departments and agencies. And third, I'll turn briefly to the article in question. To begin, I can assure my honourable colleagues that my department and my exempt staff take the safeguarding of information regarding the contents of all bills intended for introduction very seriously, and they adhere to all relevant policies and procedures. My departmental officials, through my Deputy Minister, are instructed to follow all precautions as outlined in the Drafter's Guide to Cabinet Documents and the Policy on Security of Cabinet Confidences, both of which can be found on the Privy Council's office website. According to the PCO Policy on Security of Cabinet Confidences, draft bills, with the exception of versions used for public consultation upon agreement of Cabinet, are deemed confidence of the Queen's Privy Council. These documents must be marked, handled, and safeguarded accordingly. Documents may only be handled by those with valid security clearance at the appropriate level and a valid need to know the information to perform their duties. Restricted access to Cabinet confidences extends to all stages of drafting. The following individuals are considered to have a need to know status: employees who are responsible for developing policy and for developing proposals for the minister, ministerial and departmental personnel supporting a minister on particular policy, proposal, or issue that is the subject of cabinet discussion, central agency employees who help advance policies and proposals brought forward by departments of sponsoring ministers, and legal advisors providing advice relating to a policy, proposal, or issue that is the subject of a cabinet discussion. As per PCO policy, these individuals are required to use appropriate means, including IT systems, to prepare, store, and transmit cabinet confidences, mark cabinet confidence information at the appropriate level of sensitivity and with the caption, quote, confidence of the Queen's Privy Council, end quote, on every page of the document. Handle such information in restricted access areas. Use security equipment and procedures approved for the level of sensitivity of the information to transport, transmit, store, and dispose of cabinet confidences on paper or in electronic format. Ensure that the information is not discussed with, viewed, or overheard by unauthorized individuals, and refrain from discussing such information on cellular telephones or wireless devices unless approved security means are used. All my departmental officials who worked on this draft legislation, as well as all of my exempt staff, had valid security clearance at appropriate levels. As a general practice, any security incident involving cabinet confidences, however slight, must be immediately reported to the responsible departmental security officer. This would include unauthorized disclosures, loss, theft, transmission, and discussion over non-secure channels, unaccounted documents, and other actual or suspected compromises. The departmental security officer, in turn, must immediately report the incident to the PCO Security Operations Division. Unless directed otherwise by PCO, the departmental security officer is expected to conduct an initial administrative inquiry to determine what happened and to identify corrective action. Generally, an inquiry would include an examination of the circumstances surrounding the incident, if possible, the source of the undisclosed or the unauthorized disclosure, the adequacy of the departmental procedures for the protection of sensitive information, an assessment of injury to the national interest arising from the compromise, and an outline of corrective measures that have or will be put in place to minimize the risk of similar occurrences in the future. The Clerk of the Privy Council and the Secretary to the Cabinet, after consultation with the appropriate department heads, may involve the RCM Police. The RCMP will then determine if there is sufficient evidence grounds to investigate. Where appropriate, department heads are responsible for applying sanctions. Let me be clear. I have spoken with my Deputy Minister, and I can assure you that my department follows all necessary precautions. In this particular manner, I can assure you that no breach of information nor evidence of such a breach was reported from departmental staff, and therefore no internal inquiry was initiated. Further, I can personally assure you that I spoke to all of my exempt staff about this matter, and none of them were involved in any breach of information. I believe and trust my departmental officials and my staff, and I take them at their word. Second, honourable colleagues, it's worth remembering that this sensitive piece of legislation was not crafted by the Department of Justice alone. My department worked closely and collaboratively with officials in other departments, and my exempt staff worked with their counterparts in other offices. Further, as per PCO guidelines, drafts of memorandums to Cabinet containing specific policy recommendations were shared with central agencies and other departments and agencies to solicit feedback and to address any potential concerns from various policy perspectives. As the Minister of Justice, I certainly cannot speak on behalf of other departments or agencies. Third, I want to briefly address the article in question. As you know, on April the 12th, 2016, public notice was given for the introduction of Bill C-14 in 2 days' time. Like my honourable colleagues, I was dismayed to learn that the article was published in the Globe and Mail that same day that made reference to specific aspects of the bill, mainly what would not be included in the legislation, and to a source familiar with the legislation who is not authorized to publicly speak on the bill. Let me be clear. I did not know the identity of the source at that time, nor do I know the identity of the source sitting here today. What I can offer, honourable colleagues, is that the few details about the bill in this article are not entirely accurate, and that this inconsistency between the bill and the article may be relevant to your investigation. Specifically, the article begins by stating that the bill will exclude those who only experience mental suffering, such as people with psychiatric conditions. While it is the case that those who suffer from mental illness alone may not be likely in practical terms to qualify for medical assistance in dying, pursuant to the eligibility criteria set out in Bill C-14, as it was originally drafted and tabled in the House, the proposed legislation in no way categorically excludes such individuals. It is possible, although unlikely, that someone who only experiences mental suffering could meet all of the eligibility criteria and therefore be able to obtain medical assistance in dying under the proposed scheme. It is also worth noting that the article mostly speaks to what will not be in C-14 and does not disclose major elements of the bill. For example, it does not address items like the eligibility criteria, the safeguards, and the monitoring regime proposed in the legislation. Finally, I would highlight that I'm quoted towards the end of the article, referring to various principles that our government sought to balance with this legislation, but of course refusing to go into any detail about its contents. So in conclusion, honourable colleagues, let me assure you that my department, my staff and I take this issue incredibly seriously. All matters of privilege implicate the foundational principles of our constitutional democracy, and so I commend you on the work that you are doing, and I'm happy to participate and take questions. Thank you, Mr. Chair.
Thank you very much, Minister. And we'll go to the first round of questioning of 7 minutes to Mr. Graham.
Thank you, Chair. Thank you, Minister. I may be sharing my time with Ms. Sahoda. Our study here is based on a finding of a prima facie case of breach of privilege by the Speaker, which, as we all know, refers to, at first glance, at first appearance, there may have been a breach here. You mentioned in your opening remarks that the article that is the basis of this motion contained inaccuracies about the bill. It did not obviously contain the bill itself. And the title of our study refers to the premature disclosure of the contents of Bill C-14 on a prima facie basis. So, in your view, Minister, were the contents of C-14 in fact prematurely disclosed?
Well, thank you for the question, and certainly, again, thank you for the study that you're undertaking. As I said in my remarks, there were some aspects in the article that was written on the 12th that reflected some of the excluded parts of Bill C-14, those being mature minors, advanced directives or requests, and persons suffering from mental illness alone. So what the article reflected mostly was what was not included in the legislation. And as I commented, the specific provisions in terms of eligibility, safeguards, and monitoring weren't mentioned in the article.
So the bill itself was not really disclosed, as far as I can tell. In your study, you also mentioned department security officers. Now, this is something I'm not familiar with. I've never been in such a department. Can you tell us a bit more about who they are and when you talk to them about what and what their powers are in terms of department security officers?
Certainly. We have within the Department of Justice security officers that have, upon my coming into this position, and certainly my exempt staff and departmental staff have gone through the necessary security measures in all different forms in terms of documents of a secure nature that have different levels of categorization and the requirements to ensure that those are kept protected and secret. They go through procedures in terms of where those documents can be read, how those documents should be carried, and the responsibilities that one has in terms of the security clearance that they have. So they make it very clear to myself and the exempt staff, as well as departmental officials, in terms of what the responsibilities are upon receiving a specific level of security clearance. And in this case, as I said in my remarks, when the article was brought to my attention, and certainly when it was made public in the House of Commons, I immediately acted and asked my staff and advised my deputy to do the same with the public servants to ask and ensure that we were not the source of any breach, and that we followed and complied with the strict instructions that were provided by security departmental officials.
Okay. Thank you.
Hi, Minister. Thank you so much for making yourself available and being here before this committee today. I'd like to talk a little bit more about the psychiatric condition that you were referring to that was mentioned in the Globe and Mail article. You were stating that, and correct me if I'm wrong, that they didn't really get it right. The description that was in the article was in fact not an element of the bill. Can you get into that a little bit more specifically?
Certainly. Thank you for the question. The article that we're talking about said that it will exclude those who only experience mental suffering, such as people with psychiatric conditions. And this was according to that source familiar with the legislation. I'm pleased to speak about Bill C-14 and the eligibility criteria that we have put into the legislation. The eligibility criteria does not necessarily exclude people suffering from mental illness or psychiatric conditions, but it contains a number of criteria that need to be met and circumstances in terms of the individual patient's situation and health concerns that need to be read in a comprehensive way. So a person that has medical conditions, including a psychiatric condition or a mental illness, is not precluded from qualifying to meet the criteria or the eligibility criteria in medical assistance in dying. A person that's suffering from a mental illness or a psychiatric condition alone would have more difficulty in qualifying. And the reality and what we've done in the legislation is to look through amendments and otherwise that we ensure that we study mental illness, and we learned the risks and the benefits with respect to that. And that study in the proposed legislation has a commencement timeline of 6 months.
Do you have more time? So people who worked on writing this piece of legislation within your department and the various other departments, would they have been familiar with that element of the bill? And would it be accurate to say that somebody who had worked on legislation that was privileged to this confidential material would be properly able to explain to that source would have the proper information if it was in fact somebody from within the department?
Well, the Department of Justice, as I mentioned, does not develop legislation in isolation. In fact, there are many other departments and agencies that would have been involved in some fashion and had some access to the documents, to the draft legislation, because of the need and the reality of different departments contributing towards its development and the public policy framework around it. And people have varying degrees of access to it and differing levels of investment of time in terms of its development. But everyone that had access to the draft legislation or the development documents for the legislation would have had and did have the appropriate security clearances and understood the necessities around ensuring that those security clearances and the responsibilities that go along with them were followed.
Thank you, Minister. Now we'll go to a 7-minute round to Mr. Reid.
Thank you, Mr. Chair. Thank you, Minister, for being here on what is probably the busiest month, possibly one of the busiest weeks of your life. We appreciate that. I wanted to start by dealing with two things. The first is what the Speaker said in his ruling when he sent it to us. He was talking about the difference between this issue and that of a former case where a private member's bill had been released before its time, whether a privilege issue is there. He said that at that time, with this other bill, private member's bill, no doubt existed as to the provenance of the leak, and thereby he directed us to the fundamental issue here, which is establishing the provenance of this leak. Okay. Now let me read from the Globe and Mail. What it says here is, and I'm quoting, "The Liberal government is set to introduce its much-anticipated physician-assisted dying law on Thursday, a bill that will exclude those who only experience mental suffering, such as people with psychiatric conditions, according to a source familiar with the legislation. The bill also won't allow for advance consent, a request to end one's life in the future, for those suffering from debilitating conditions such as dementia. In addition, there will be no exceptions for mature minors who have not yet reached 18 but wish to end their own lives. Those three issues, however, will be alluded to in the legislation for further study, according to the source, who is not authorized to speak publicly about the bill." So and end quote, you made two assertions. One is that only negative information is included. That's not strictly true. These issues will be alluded to in the legislation for further study. That's positive information about what's in the bill. And you also say that the leak is incorrect on some of its information. I have to say, with regard to the issues of incorrectness, that this could well be a result of the journalist, Laura Stone, making a transcription error in an interview. So it may not actually be the source that was incorrect. Additionally, with regard to only negative information being included, first of all, it's not, strictly speaking, a true statement. But secondly, I would submit to you that disclosure of what is not in a bill actually implies a greater comprehension of the complete content of the bill than merely being able to point to individual features that are in the bill, which could have resulted from somebody who only was familiar with a part of that legislation. And so that would suggest, if we are sincere, if the government is sincere in its search for the provenance, the source of the leak, that it ought to be looking at someone who is familiar with the entire text of the bill. But let me ask you this question. I apologize for being so direct, but I'm sure you'll appreciate why I need to do this. Are you the source of the leak?
Well, appreciate the question because it gives me the opportunity to be crystal clear. I do not know the source of the leak. I did not know when the article came out where the leak came from. It was of tremendous concern to me that somebody had information about a fundamental piece of legislation that I was going to be introducing. And today, as I sit here, I do not have any idea the source of the leak. I am confident,
Right.
however,
I wanted to be very clear, but that's why I
my-
gave you that question, so you could make that clear. I appreciate that. You mentioned there were other departments involved. So the ones that come to my mind, and I'm asking you if I've got the whole list here, are Justice, obviously, Health, PMO, and PCO. Would there be additional departments, or is that the complete list of where the leak could have come from?
Well, I'll answer the question, but I'm not inferring in my answer that I have any idea where the leak came from.
It wasn't meant to draw that implication.
In developing the legislation, certainly the Department of Justice was involved and engaged with many other departments and agencies. And you're correct in saying those included Health Canada, and certainly on such a transformative piece of legislation, the Prime Minister's office was aware of the contents of the legislation.
Are you aware, and it may very well be that you're not, but I want to ask you this question. So are you aware if the other departments have engaged in a similar sort of process to the one you described in confirming where the leak could have come from? And in other words, has there been an investigation in any of the departments to your knowledge? Perhaps you don't know that, but I'll just ask that question.
Well, I can speak with confidence on behalf of my department. There's no evidence of a breach with respect to my department. I'm confident that the breach did not occur within my department, but I can't speak on behalf of any other departments.
Fair enough. So I think the answer is you just don't know about that, about the other departments, any internal investigation.
I feel confident in speaking about things that I have direct control over.
Okay, that's fantastic. That's very much appreciated. I wanted to ask this question. As I say, I think that the explanation for any incorrect information, and it would be, frankly, a very slight technical error, can be explained by the journalist misunderstanding what would have been a verbal conversation. But it's also possible, and only you would know this, whether it is the case that the wording as described in Laura Stone's article in the Globe and Mail is consistent with an earlier draft of the bill. If our goal is to search for the provenance, the source of the leak, then it is not inconceivable that it could be someone who had access to an earlier draft. So I'm asking you now, is the information inconsistent in the ways you described to the current wording of the bill, or the bill as it was released, but consistent with an earlier draft? If so, we can narrow our search to individuals who had access to that version of the bill, but not the final version. So.
Well, you've mentioned a number of times about the reporter, and potentially it was a technical error in terms of the reporting. I can't say one way or the other in that regard. The draft of the bill as it was introduced, and every previous draft, however different, if they were different at all, are subject to the same confidences of the Queen's Privy Council, and the same procedures, whether it was the final bill that was introduced or previous iterations of that bill, are subject to those same security realities, and again, confident that we followed all security measures.
All right. I just want to say thank you. I really do appreciate you taking your time, and what really is a very busy time, and being as helpful as you've been. Thank you.
And if I could, Mr. Chair, I want to thank the member for the thoughtful nature that you engaged with your constituents around Bill C-14.
Oh. Yes, 67% voted. In case people were wondering, we had a constituency referendum. 67% of my constituents voted in favor of Bill C-14 on what I thought was an objectively worded question. So there you are.
Thank you. Now we'll go on to Mr. Christofferson for 7 minutes.
I hate to break up this mutual admiration society we got going here, but we got a bit of a study we got to conduct. So I want to thank you also, Minister, especially for accommodating during our time. We had opened up to meet with you at any time that would fit your schedule, and you were good enough to meet during one of our regular times. We do appreciate that. Thank you very much for being here. And a personal apology, what started as a minor irritant last night is now a full-blown head cold, so forgive me for my condition. I'll do the best I can to get through this. Do you believe there was a leak? I think that's kind of been asked around about, but was there a leak?
Well, I recognize and think about the timeline, and our notice paper went up with respect to the introduction of our bill, and there were reflections around the legislation in the article that we're talking about. Whether or not that was a significant and substantive correct guess or not. All I know and what I'm confident of is if in fact it was a leak, it certainly was not committed by the Department of Justice.
Yeah, and that poses, I lost my mic, thanks. And that poses some interesting questions, because you started out almost dissecting the information that was out there, and it led me to think you were suggesting there wasn't a leak, and even now you're a little less than just straight up about whether or not there was a leak. And I give you another opportunity. Can you just give me straight up, do you believe that there was a leak or not, ma'am?
Well, I would like to consider myself always being straight up in the answers that I provide. There's obviously some information that the reporter gained access to. How she was able to do that, I can't and won't hypothesize as to that, but what I have done and what I will continue to do is to fundamentally respect the principles of our constitutional democracy, and my responsibility to ensure that I abide by those, and recognize that this breach that has occurred and the reason for your study is a very serious matter, and I look forward to the results of your thoughtful discussions.
Great. You know what? I'm not a lawyer furthest thing from it, but leak and breach are close enough to me, because if there's no leak, we shouldn't even be meeting, and somebody should be making the case that you're chasing it's a wild goose chase that's not going anywhere. So the fact that you're willing to say there was a breach means that we do have something here. You know, the last time we talked about this for a very brief time, your chief government whip was in the room, not at the table, but in the room, and I alluded to that, and I asked whether the government had initiated an internal investigation from the get-go. So was there, I know you asked some questions, but was there what you would call an investigation? Did you turn to your deputy and say, I want this investigated and I would like a report?
Well, I appreciate the question, and upon being made aware of the article and hearing what transpired later on in the House of Commons, as you can appreciate, I was very busy that day introducing the legislation, and had many events surrounding that in terms of media avails and briefings of members and senators. Upon learning of the breach, leak, whatever we want to call it.
We're getting there.
I did contact and discuss with my exempt staff if they knew anything about this, and I was assured that they did not. And I also contacted my deputy, who did the same. There is no evidence of a breach coming from my department, and by virtue of the lack of evidence, no investigation was done beyond what we did in terms of engaging with our staffs.
And is that sufficient, though? I mean, the reason there's an investigation, it does suggest something a little wider and further. You talk to the people who were around you. I used to be a provincial minister, so I get the kind of people that are around you on a day-to-day basis, but that's not the same as formally sending out an investigation to ask for a report on it. Is there a reason why you didn't sort of go to that level? Because all your descriptive words have been tremendous concern, you know, and recognizing the breach/leak as something that matters. Is there a reason why, ma'am, that you didn't ask for a formal investigation, recognizing that this very day could happen?
Absolutely. I have the utmost confidence and belief in my exempt staff, and certainly recognize and have confidence in my deputy and the public servants that work in the Department of Justice. They have the utmost of professionalism, recognize the severity or the seriousness of ensuring that we maintain confidences and that confidential documents, security levels are adhered to. And in this case, there was no evidence to necessitate a investigation as I described in my remarks.
All right. There are protocols for the release of bills, given the importance of making sure that Parliament hears it first, which is a right and a privilege of members of Parliament. The previous government, upon finding out there had been a leak, amended the protocol. And I'm curious as to whether you're still following that same amended protocol from the previous government, or whether or not you had a new one. I went into cabinet after the government had been formed, so I wasn't there for the immediate handoff of the previous government, so I don't have any personal experience in this regard. So I'm just asking because I don't know. But the protocol, so again, were you using the last amended version that the previous government had as a policy? And that's not a criticism, just a question. Or did your government come in and rewrite those for your own policy steps and guidelines in terms of introducing legislation?
Well, thank you for the question.
Just briefly, Minister.
As I stated in my remarks, we follow the drafter's guide to cabinet documents, and we follow the policy on security of cabinet confidences, both of which are located on the Privy Council Office's website and certainly accessible to determine the dates in which those were brought in.
Thank you. Thank you. Okay, now we'll have Ms. Pettipas-Taylor sharing with Ms. Vanderbilt for a 7-minute round.
Thank you. Thank you so much, Minister, for joining us this morning. As you're aware, PROC has been asked to investigate this matter, and a part of our job is to really collect as much information and facts as possible, so we appreciate you taking the time and meeting with us this morning or this afternoon. I guess my first question that I have for you, Minister, do you feel that you took the security matter seriously? When you became aware of this potential situation, do you feel that you took this matter seriously?
Yeah, absolutely. When I became aware of this, as I stated, it concerned me greatly and compelled me to almost immediately call my exempt staff and to engage with my deputy to ask the questions if we knew anything about it and to follow the procedures and confirming that my staff and the departmental officials were not involved and followed all procedures.
Okay, thank you. You indicated that you immediately acted when you became aware. Could you tell us, perhaps explain to us or elaborate what steps were taken in more detail with respect to that?
Sure. I became aware of this discussion, the article, the breach of privilege that was talked about in the House of Commons after I came back from a press conference around Bill C-14 and was in the House and heard Chief Government Whip speak. And of course, as with every member of this committee and all members in the House of Commons, take privilege very seriously, and so it was a concern to me, absolutely. And at that point, I engaged in discussions over BlackBerry and called my staff in my office and spoke with all members of my exempt staff that have the security clearance to view cabinet documents, and also spoke with my deputy minister who I advised of the situation. He, of course, had already read the article, and we ensured through our conversations with exempt staff and our departmental officials that obviously this is a serious concern, but confirmed that we had followed all security measures as articulated in the policies that the Privy Council office has.
And when you talk about exempt staff, what process do they go through to become exempt, quote unquote?
There's a hiring process, certainly in all ministers' offices. The hiring process is not necessarily the same within all ministers' offices in terms of how many people want interviews, but there's an interview process, and when somebody is made an offer of a position, that person is subject to the rules that are in place with respect to the Privy Council office. They're subject to quite extensive security clearances in order to achieve whatever level of security clearance they're deemed appropriate to have, and are obliged through that process to follow all of the measures that are in place around confidences in terms of documents, memorandums to cabinet, development of policy papers, and the like. So there's a substantive security clearance that ministers' offices staff or exempt staff have to go through.
Okay, thank you. And did you report a possible security breach to the Department of the Security Department?
I did not report to the departmental security department for the reason that there was no evidence that the breach had occurred within my department or within my minister's office.
Okay, thank you.
Thank you.
Thank you very much, Minister, for being here today and for taking this matter so seriously. I'd like to go back to some of the things you said about the article itself. The fact that, on the one hand, there was inaccurate information in the article. In fact, you talked about inconsistencies, and with all due respect to my colleague, Mr. Reid, I think that when you're talking about something as important as the eligibility criteria, it's not likely to have been a transcription error. So what was in the bill and what was in the article were actually not the same. Secondly, the article focused more on what was not in the bill as opposed to what was in the bill. And even then, I think I heard you say that it was very much around the general principles. So would you say that, in terms of what you call the correct guess, is this information that could easily have been inferred from things that were already in the public or things that had been shared during the consultation process prior to the notice period and the tabling of legislation, that this was general enough information that it doesn't prove that anyone actually had the text of the bill that wasn't supposed to?
Well, thank you for the question, and my answer to that is it's a possibility. Certainly what's referenced in the article speaks to exclusions from the bill, speaks to mental suffering, mature minors, and advanced consent. Those were there are controversial issues. They were certainly issues that were substantively discussed in the Special Joint Committee report. So I don't think that it's beyond the realm of possibility that one would think that any piece of proposed legislation might make reference to those issues. That's my answer.
Your department has very strict protocols. You outlined some of those, and there was never any breach that was reported to you from your department. Can you elaborate on that?
Certainly.
Certainly. Nobody in your department came to you and said, I left it in a taxi cab, or there was never anything reported in terms of any potential security breach.
There was never anything reported, and if there was something where there was a lost document or the like, some sort of breach of security protocols, those would be immediately reported to and through my deputy to me, and I never received any report.
Thank you very much. We'll now go on to Mr. Richards for a 5-minute round.
Thanks, Mr. Chair. So I get a sense, like, although you seem to somewhat dispute the potential on the one part of the bill that the leak or the potential leak, the person has indicated in terms of the mental suffering. And I think that's a matter for dispute. I mean, that's a matter of opinion. I think there's many people who would argue that are opposed to the bill that maybe that actually in practice is something that's excluded from the bill, but we won't dwell on that because it seems to me as though you do sort of indicate that you believe that some of these other things certainly are excluded from the bill, and the person was correct who has made these assertions that these things are excluded. And so I get a sense that that the fact that there's a potential leak here is something that upsets you. I think I'm getting that sense from your testimony and from your answers today that if there's a potential for a leak here, and that's something that you're quite upset by. Is that an accurate portrayal? That bothers you?
Why, of course. I mean, I think that a breach of privilege should impact all members of Parliament. It's a serious concern, and appreciate the efforts that you're all undertaking in this regard.
Good, and I appreciate that. I do appreciate that you're taking this seriously and that you're trying to be as direct as you can with your responses. And I would assume that, based on that if there was a leak, and it to me seems as though there has been, I would assume that if there was a leak, though, that you would want to see that source discovered and you would want to see that issue be addressed, correct?
Sorry, I didn't catch the last.
If there was a leak, that you would want to see that source discovered and you would want to see the issue be addressed, correct?
I think that everybody wants to uncover the information if in fact there was a leak.
Sure. So you would obviously desire that this committee do everything it can and make every effort it possibly can to discover the source of that leak, correct?
Well, I think that this committee is undertaking a study to do just that.
But you would agree that that's an important goal.
Yeah, absolutely.
So you've mentioned a number of times, obviously you talked a little bit, and I don't have time to go into the details of the investigation that was done in your office. I wished I did. But you believe quite confidently that it was not the source of the leak within your office or within your department. But you have mentioned, of course, that there was other departments and agencies that had access to the contents of the bill. You mentioned specifically the Department of Health. You mentioned the Prime Minister's office as being two of those potential places that would have access to the bill. So it would seem fairly obvious to me that the next steps for us would be to ask people in the Prime Minister's office, department, probably the Minister of Health, to determine what's been done, and if there's been a similar investigation done, as you weren't aware whether that was the case or not, whether there's been similar investigations done by the department and the Minister's office and the Minister of Health, and also the Prime Minister's office. That would seem our next logical steps for us to be able to follow. So I wonder if you could give us some sense as to, because it would seem the most likely source, obviously, would be communication staff in the Prime Minister's office, maybe communication staff in the department or the Minister of Health's office as well. Could you give us some sense as to who those individuals might be, so we would know who we should be calling? We have to have some sense as to how we would conduct an investigation into the Prime Minister's office and their handling of the contents, and also with your colleague, the Minister of Health, in her office. Could you give us any sense as to who we might call?
Well, maybe if I could just repeat some of what I said in terms of this piece of legislation wasn't drafted by the Department of Justice alone. My department, and I'll be very clear on this, worked closely and collaboratively with other departments, and my exempt staff worked very closely with their counterparts. Further, and as per PCO guidelines, drafts of memorandums to Cabinet containing specific policy recommendations were shared with central agencies and other departments and agencies to solicit feedback.
Very limited
and
on
all
time
of those
here.
individuals have secret or beyond secret clearance.
Understood, but I'm very limited in time, and we have to get some sense. I mean, obviously, you're indicating clearly that you believe it was not in your office that this occurred, so it must have occurred either from the PMO or the Minister of Health's office. So we need to have some sense as to who we would need to call. Would you know how many staff, who would have had access to these documents in the Prime Minister's office, for example?
In 20 seconds.
Well, given the references in terms of the departments that were involved in the development of this legislation, there's a substantive number of people that were involved. And given the magnitude and the transformative nature of this legislation, of course the Prime Minister's office saw the legislation, so there's a number of people that many people that saw it.
Thank you.
I'm not going to.
Thank you. And so it would sound like the next step would be to call the Prime Minister's office officials and the Department of Health. So thank you very much.
Thank you. Mr. Lightbound for a 5-minute round.
I first want to thank you, Madam Minister, for being here. I think all issues of privilege ought to be taken seriously, and we certainly take that seriously here, and we appreciate the rigor that you bring to this committee and your presence. The first thing I wanted to ask you is regarding the procedures, especially as they pertain to draft legislations and the directives of the Privy Council's office. You went pretty quickly on them. I noted that you talked about the mark that it has to have, and so I'd just like you to elaborate on those policies, especially as they concern draft legislation.
Sure. There are different levels of security that are assigned to documents. Documents that go to Cabinet, memorandums to Cabinet, are subject to the confidence of the Queen's Privy Council. And in terms of the development of legislation, as I indicated and as you referenced in my remarks, that people are considered involved and that have security clearances would be employees that are responsible for the developing of the policy and the proposal, in this case to myself as the minister, ministerial department and department staff and personnel that support me in terms of making particular policy choices, central agency employees who advance the policies and the proposals brought forward by departments of supporting ministers, and in addition, the legal advisors providing advice on the policy, on the proposals and the issues that are subject to Cabinet discussion. But all of those documents that contribute towards that are marked subject to the Queen's Privy Council and are secret documents. And in order to review and participate in those documents, you have to have a high level of security clearance.
And it's fair to say that based on your inquiries with your exam staff and your deputy minister, all of these procedures were followed by your department?
100%.
100%. So, based on that inquiry that you've made, there is no breach in the chain of possession, so to speak. Like it's clear that a material copy of the bill could not have ended in the wrong hands, so to speak, because those policies were followed, and there was no evidence of a leak, let's say lost USB key or whatnot.
That's correct. There was no evidence of that, and individuals are obliged to come forward and disclose that if in fact that were to ever happen.
Okay, and my other questions, that policy you've just described to us is applicable across all departments, all ministers or departments are subject to that PCO policies?
Both of those policies are, every department and staff and departmental officials are subject to those policies.
Okay, and how much time do I have left? 2 minutes? Okay, so on my last question would be, coming back to the article, as I was reading the article, and I've read it a couple of times in the course of our study here, it seems to me like anyone who would have paid attention to a lot of the comments that were made by the government regarding the protection of vulnerable people could have inferred that those exclusions would be somewhere in a bill, especially if you consider the experience of the National Assembly where those exclusions are in the Quebec bill as well on assistance in dying. So I guess my question would be, would it not be possible that this could be an educated guess as well, that protection of the vulnerable would necessarily include or could include those elements that we see in the article? I'd just like to have your take on that.
Well, it's a possibility that it was an educated guess. There was substantive discussion that has transpired over the course of many months from the Special Joint Committee to recommendations made by the Provincial Territorial Panel and the external federal panel on medical physician-assisted dying at the time. So the answer to the question is possible.
Okay, that concludes my questions.
Okay. Finished early, so we'll go on for a 5-minute round to Mr. Reid.
Minister, your response to Mr. Lightbound's question just a moment ago, am I to understand that you were saying that the information that was contained in the Globe and Mail article would have been known to members of one or more external panels that you had named? You said there were 2 external panels you made reference to just a moment ago.
No. My response to Mr. Lightbound was to the question, is it possible that somebody could have made an educated guess that there were these items that would have been considered in the legislation? I spoke about the special joint committee. The point that I was making, perhaps very inarticulately, was that there's been some substantive conversations about physician-assisted dying, medical assistance in dying, more controversial issues, whether it be mature minors, advanced directives, or persons suffering from mental illness that were considered in many different reports, including the report of the Special Joint Committee.
Okay. I must say, while this is not conclusive, the wording used in Ms. Stone's article suggests that it would have been a narrower circle of people who, I'll just read what it says again, these 3 issues will be alluded to in the legislation for further study according to the source, who is not authorized to speak publicly about the bill. To me that suggests, although obviously Ms. Stone would have taken care to keep the identity of her source confidential, it does suggest somebody who is somewhere inside one of the departmental apparatus. I'm not sure what the plural for apparatus is, apparati? At any rate, within one of the departments of the government as opposed to an external panel. That's just my sense. But I just want to go back to this question. The kind of person who's likely to leak something, if it's a deliberate leak, and this does seem to me like a deliberate leak, is someone who's involved in communications. So would you have information, you must have information as to where these documents were circulated, the later drafts of the bill, the summary of the bill, because this could have come from a legislative summary. Do you have information as to which people in PMO would have seen that, or do we need to go to PMO to ask the question as to which people in that department would have had access to either the bill itself or to the summary drafts of the bill?
Well, leaving aside your lead up to the question,
sure.
As I said, with a substantive piece of legislation such as this one, not only the Department of Justice but other departments involved in the production of the legislation, central agencies, and certainly because of the magnitude of this piece of legislation, the Prime Minister's office would have been certainly privy to this proposed legislation.
Right.
All of whom would have the appropriate levels, obviously, of security to be able to review such documents.
But it's not an infinite list. What we're trying to do in order to get to the provenance of the issue is to narrow it down. Would you be able to get back to us, perhaps in writing, with a list of all the individuals who were informed of it, or at the very least, the departments that were in the loop and those that were not inside the loop with regard to either the law itself or the legislative summary?
Well, I appreciate the question, and I'm not trying to prevent getting at the source or the details or being in any way obstructive to the question. I have, as the Minister of Justice, 4,500 employees that work in the department.
But they didn't all see it, obviously.
They didn't all see it, but I imagine that we can all appreciate a piece of proposed legislation that requires approvals. That is
but there is a list.
Legislation
there is a list of those to whom any confidential document is circulated. You have to recall those copies, so you know everybody to whom at any stage there'd be a record of those to whom it was circulated, both in your department and in others.
In 20 seconds.
What I know and can speak in terms of having confidence is for my department. And I know people that have access, what levels of security access they have. Certainly our department has departments within it that are responsible for particular aspects of the Department of Justice and the role that I play as minister, and recognize that my individual exempt staff have responsibilities as well. And I know that who was involved in medical assistance in dying and have canvassed all of the staff in terms of us following the appropriate security measures.
Thank you, Minister. Now we'll go on for a 5-minute round to Ms. Hoda sharing with Mr. Graham.
Thank you, Minister. I appreciate you being clear on the topic of members' privilege here today. And if I could just clarify some other things with you, I'd like to, we're talking about whether there was a breach of a member's privilege and whether the article and what was contained in the article actually arises to that definition of a breach of a member's privilege. And I'd like to get your opinion on whether you think there was an actual premature disclosure of Bill C-14.
There's nothing that has come to my attention that there was a premature disclosure of Bill C-14. I and my department in no way, shape, or form would disclose such a sensitive piece of legislation.
Thank you. And I'll be sharing my time with David over here. Mr. Graham.
Thank you. It's nice to be back. In the last meeting when you were not here, we discussed a good deal about the 41st Parliament, where a large number of government bills were discussed at great length by the ministers themselves and the press, and at no time did a breach of privilege ever even come to be discussed. I was going to give you a chance to react to things like the Fair Elections Act having the quote in the paper, "The bill would remove the Commissioner of Elections Canada, of Elections Canada, where the investigators work, from Elections Canada and set it up as a separate office." Sources say there's all kinds of very detailed descriptions that were not considered breaches of privilege because the bill wasn't released. Do you see any similarities between here and the previous practices of they release the bills directly, and do you see any comparisons here?
Well, I mean, there may be comparisons, but what I know is reflecting on this particular circumstance with respect to this proposed piece of legislation. The conversation of physician-assisted dying, now medical assistance in dying, in the context of the proposed legislation of C-14 has been a conversation that we've been having in an expansive way, at least for the last 7 months, that we've been able to, at an the Special Joint Committee has been having that conversation, and myself as the minister that has been tasked to work on this legislation have been, as much as I can, in the development of the legislation, sharing information with Canadians about the thoughts that were being put into the legislation in terms of ensuring that we do our part to hear as many voices as we can to find balance in terms of personal autonomy and the protection of the vulnerable. These are words that I have used in advance of the tabling of the legislation, I continue to use today, although now that the legislation has been tabled, I can go into detail about how we found and sought to find that balance in C-14. So I have been speaking to that balance all along.
Fair enough. And we're down to about a minute and a half or something left of this meeting.
You won't have your full time. There's only a minute left.
Life is terrible. Okay. That's fine. So just to wrap this up, I would like to really come back to our study is very specific to saying the premature disclosure of the bill. And as far as I can see, and as far as my colleagues have the questions have taken us, there was no premature disclosure of the bill. So where do you see this matter going? Where could we go further with this, if anywhere?
Well, I mean, I certainly wouldn't impart on this honourable committee what next steps are, but what I would like to do, given that the time is running out, is to assure this committee that breaches of privilege are taken and should be taken incredibly seriously, and all individuals that had access to Bill C-14 and its developmental documents have the necessary security clearances, and we have substantive policies of the Privy Council office that ensure that we abide by the security provisions to ensure that confidential documents remain in the confidence of the Queen's Privy Council, and I'm confident that those were followed across the board.
Thank you, Minister, and thank you for appearing today. You can go. Thank you.
Thank you.
Mr. Christopherson.
Thanks. My point of order is we're dealing with the question of privilege of members But is it not fair to say that given some of the testimony from the minister, we may also be dealing with someone who has broken their oath? Because the minister alluded to a number of times about people being under the oath in terms of the level of secret or above secret, and she mentioned it 2 or 3 times. Does that not suggest that this isn't maybe just a question of a breach of members' rights, but someone has violated their secrecy oath?
Well, I think we can discuss that in the future. Yeah, our time's up. But bring that up. Okay. We're adjourned. Thank you.
Thank you.